thank you for coming to Chicago.
My pleasure.
First experience here?
First experience. Never been here before. I'm enjoying it immensely.
Well, we hope it's not your last. And was your mom and dad lawyers? Was this law?
Oh no, my father was a movie director. I grew up in Beverly Hills. Okay. He was born in Brooklyn, and did live theater, then live TV, then flew out to L.A., Beverly Hills. I followed him in 1953, and grew up in a community that was centered in the movies. Never graduated college, my father.
So your dad, like Jackson, never graduated college, and was he blacklisted?
No, he was not blacklisted, although many of my friends were children of blacklisted, like Richard Dreyfuss was in my class, his father was blacklisted. I think you're doing a tribute to Carl Reiner. Rob Reiner, his son, was in my class. Many of the kids came out of a blacklist situation.
So when you say class, was this high school class?
High school class, Beverly Hills High School in 1965.
Did you want to get into the theater?
I would love to get into theater, except of no talent. So that was that.
Yeah, that'll do it.
It'll do it every time.
Well, next time you do come here, the National Comedy Center is just down the road in Jamestown, and you'll get to see a few people who did have a little bit of talent. So law was not part of your background. What kind of was the aha moment for you?
Well, I went to Harvard undergrad, and then I got a PhD, actually it was ABD, in American Studies, and decided that that really was not the future for me, and I went to law school. I went to Yale from Harvard, and I had really lovely people who took care of me on the faculty. I clerked for David Bazelon, who was then Chief Judge of the DC Circuit, and then for William Brennan, who was on the Supreme Court, and I practiced as a litigator for Williams and Conley, and finished my dissertation while I was litigating. So, and then I decided, well, really I want to be an academic. So went to Berkeley, and was there for 20 years as an academic, came back to Yale in 2003, and became dean in 2009, left that 2017, and here I am, a happy person, just a professor.
You just dropped a couple of big names, but William Brennan, how did that clerkship occur?
Well, the faculty member to whom I was particularly close was named Owen Fiss, and Owen was very close to Brennan. And so one day Brennan called me up and said, would you like to clerk?
No kidding. So you hear so much about sort of that reference networking, Harvard, Yale, and they knew somebody who knew somebody, kind of the Frankfurter line.
It's a funny story, I applied before the Supreme Court. I applied to two appellate judges. One was a fellow named Henry Friendly, who was important on the Second Circuit, and the other was David Bazelon. I chose Bazelon, and someone else who took the Friendly clerkship was a fellow named Merrick Garland, who later went on to clerk with me with Brennan.
Okay. So has he given you a call? He called you recently and said, you need some advice?
Merrick is an old friend, and he knows to separate friendship and work.
Those jobs, God bless them only because you think about the gravity of it all.
I think Merrick has the hardest job of any Attorney General since Leonard Levy. He has to reconstitute the Department of Justice, has to give it back its professional integrity, and he has to do that at a time when it's called upon to do very many unusual things, and things which it wouldn't have done had things been normal. So it's a very complicated position he's in.
And you're glad to be in Chautauqua today?
I am very glad to be in Chautauqua. It's calm, it's beautiful, the lake is gorgeous. The people here seemed interested and earnest, and it's a pleasure to be among people who want to improve themselves, who want to learn things.
Well, no doubt, and there'll be a significant crowd tonight to listen to Professor Siegel and to what she has to say, and of course her scholarship is terrific. But your scholarship is also. And so I want to talk about the Holmes Devise. Along the ways I had a chance to interview William Wysick.
Oh yeah.
And that's when I learned a little bit about the Holmes Devise, and I'm not a constitutional law guy, I'm just a I'm a development lawyer.
Take away the just from that.
Yes, exactly. And so I'm always intrigued by all of that. So the devise itself, or the camera, kind of an explanation of what that is. So
when Oliver Wendell Holmes died, he left all of his estate to the government in his will. And this had never happened before. You know, the government takes your estate by estate taxes, but it doesn't actually get left money in a will. So they didn't know what to do with it. And they sat around debating and debating and debating. Felix Frankfurter was kind of like the guy who was in charge of this. And eventually they decided by the 1950s, been sitting around for 20 years, that they would use it to fund a more or less official history of the Supreme Court of the United States. So the editor of the series is appointed by the president, and so are the board of advisors. So I report to someone who is politically selected. The money comes from Holmes's will, and it's been a very, let's say, troubled history, to say the least. So the volume I have, which is the period when William Howard Taft was Chief Justice, 1921 to 30. This book was originally given to Alexander Bickel to write. He didn't finish it and he died. Then it was given to someone named Robert Cover to write. He didn't finish it and he died. And then it was given to me. So
You're looking healthy. I'm feeling good about this one.
So I tripled my life insurance and I accepted the assignment. I got this book in 1988. 1988. And I just sent it, the manuscript, to the press 2 weeks ago. So I'm feeling light as air.
So you talk about a time period. Obviously, there are the cases, there are the personalities. Is it kind of a half biographical, half case analysis? How does it structure itself?
Well, every author does it differently.
Yeah.
You know, Bill did a thing on legal formalism, classical legal thought, and its connection to the court. It's taken me a while to think about what my overarching themes are. It's one reason it's taken so long to write this book. I have a magnificent court. I have a court that consists of, two of the best justices ever, Oliver Wendell Holmes and Louis Brandeis. I have William Howard Taft, who was one of the most significant, someone who changed the nature of the federal judiciary, changed the nature of the Supreme Court, changed the nature of the Chief Justiceship. I have George Sutherland. I have Harlan Stone. You know, I have unbelievable figures, but the court itself is a kind of a muddle. I mean, if I asked you to name 15 decisions of the Taft Court, I bet you couldn't do it. And so it has kind of lost itself to memory. And the question is, that being the case, how do you frame what your history should be about? And finally, a number of things brought it into focus for me, among other things, Trump. Because Harding made the Taft Court. He appointed 4 justices in 15 months before he died. So it was an extensive effort to remake the court for an ideological end. He wanted to restore what he called normalcy. Mm-hmm. And that is to say that World War I changed everything about the way the U.S. functioned. I don't know whether you know much about World War I and how it affected the legal structure, constitutional structure of the United States, but during World War I, the federal government, for the first time, and really only time in its history, took over the telegraphs, took over the railroad, took over the shipping industry. It set prices for food, for energy, for everything that was traded. It set labor prices. It was the most massive government intervention in the economy in the history, and I think probably ever. And this was in the context of Lochner. This was in the context of a court which says the government can't do this, government can't do that. It's a libertarian court. And suddenly the government took over everything in order to prosecute the war. This is an amazing, amazing intervention. And everybody in the country realized that you had to have government control of this kind if you're going to fight a 20th century war, because you're fighting Germany, which is a centralized economy, which had made everything efficient for war production. And if we didn't make everything efficient for war production, we couldn't compete in that theater. So everyone understands you need this kind of government intervention to survive in the 20th century, and nobody wanted it. Wilson loses the elections for Congress in 1918 because everyone was terrified of what had happened. And as soon as armistice is reached, he disestablishes all these wartime agencies, and it's just a pell-mell retreat from it, and nobody knew what to make of any of this. So it was a decade in which Harding wanted to reshape the court to say, let's keep away from that. And at the same time, it was in the middle and associated with a culture war like we have now that was urban and rural. It's called Prohibition. Yeah. The fight over Prohibition eclipsed everything else during the decade of the 20s. You're either wet or you're dry, like you're either red or blue now. And if you look at the dry states, they're red states now, and the wet states were blue states now, similar sort of thing, but it was really rural urban like it is now. And that fight was so fierce that Congress in 1920 looked at the census, the 1920 census, where rural inhabitants would have lost their dominance for the first time since the beginning of the country, and it did not reapportion because it would have meant the weakening of prohibition. One and only time in U.S. history we didn't get a reapportionment based on a census. That's how fierce the culture war were. And if you talk about the realignment of the country to go democratic in 1932, that actually begins in 1928 because ethnic minorities and immigrants in the cities thought that they had ratified an amendment, an 18th Amendment, which prohibited intoxicating beverages, but rural evangelical churches, through the first and most powerful ever single-issue lobbying group called the Anti-Saloon League, led by someone named Wayne Wheeler, who was extremely powerful from this neighborhood, that reinterpreted intoxicating beverages through the Volstead Act to mean anything with 0.05% alcohol, which means it was bone dry. Yeah. And that turned urban ethnic workers into Democrats, because Al Smith is the nominee in 1928, and Hoover, who calls prohibition the noble experiment, is the Republican nominee. And from that point on, urban workers before 1932 turned Democratic. It's over a culture war issue, not over an economic issue. Isn't that interesting? Yeah. So a lot of the 20s is like now.
The only case that comes to mind during the 20s is the baseball antitrust case.
Yes.
Did you talk about
Holmes, no, not very well. Holmes rules that it's not an antitrust violation. McReynolds sends them a note saying, "You are the nicest man in America," after that decision. Holmes hated antitrust law, so it's no surprise he should find it. Although now, that wouldn't be true.
Defies logic.
Yeah.
Did you talk about McReynolds? He seems to be a curmudgeon who just simply didn't get along with anybody.
McReynolds is a very underestimated justice. He's extremely influential on the court, but also goes his own way. He is the justice most likely to dissent on his own of any justice. If you look at his vote, we think now of the four horsemen of the apocalypse during the New Deal. We think of McReynolds, Butler, Sutherland, and Vandevanter, of whom two of those are appointed by Harding, Butler and Sutherland. But McReynolds is really quite a different kettle of fish. McReynolds is a Southerner, and he carries the quintessential American conservative faith, which was dominant in this country until Taft, really. And that faith was that what makes law is that it's customary. That's why he identifies the 14th Amendment liberty with common law protections. So Sutherland believes what is moral is legal, which is exactly the opposite of what Holmes believes, which is that there's a difference between the legal and the moral. So McReynolds is the polar opposite of Holmes. McReynolds wins as much as he loses on the Taft court, but writes some very lasting opinions, like you probably know Meyer versus Nebraska or Pierce versus Society of Sisters. These are McReynolds' opinions in which he has a very capacious idea of liberty under the Due Process Clause. We're going to talk about that later with Riva talking about the abortion right. It would certainly come under the way in which the capacious definition of it that McReynolds gives, only McReynolds would have defined it as what the common law had protected. So custom is the key to law, custom is the key to constitutional law, and that's the way McReynolds saw the world. Taft, Sutherland, they also had these parts to them, but they also saw the world in a way that understood property rights functionally. They said it's important to protect property because property is what creates civilization. It would create surplus capital, allows us to grow wealth faster than population grows. It's the answer to Malthus. That's their view of property. That's not McReynolds' particular view of property. McReynolds is always about morality, less about property, more about morality. But we would call them now, Taft and Sullivan, we'd call them neoliberal. They believed that the economic growth of the country, prosperity, is more important than anything a legislature could decide, because there's more consensus over that, which is why they use the property clause to trump many, many forms of regulation of the market.
In doing the Holmes Devise project, which you talk about this analysis, case analysis, the jurisprudence, did you talk about the interpersonal relationship
Very much. I had access to all of the archives. You know,
Yeah.
Taft has 650,000 letters in the Library of Congress, which I had to read. And every day he would, at the end of every week, he would sit down and write a summary of who he talked to, all the gossip. So I have all the gossip on the court.
My gosh.
And you know, there's extensive letters by Holmes. He's writing Lasky a lot during this period. Brandeis also has a lot of letters to Frankfurter during this period, but it's interesting, Frankfurter burned his letters back, so we don't have Frankfurter's replies. And Brandeis's letters tended to look like lists, laundry lists of things to do or observations, whereas Taft is very narrative, and Holmes is also very narrative. And Harlan has a fair amount of letters. He comes onto the court in 1925. So starting then, I have his letters to his family, and he has a lot of letters to his friends back at Sullivan and Cromwell, where he had practiced and so on. So I have a fair amount of correspondence, a lot of gossip in there.
With that gossip, I know we're in the world of attribution and verification and corroboration. Did you use some of that?
Oh, all of it. This book is 2,000 pages. And so I viewed it as one function is to bring this extremely rich archival record to text that people could read. You know, you had to go from archive to found, and you have to also read a lot of unintelligible handwriting, and a lot of it still I can't read. So much remains to be discovered. But I tried to put a lot of it, as much of it as I could in, so people who want to discover what was actually going on can, if they want to see the gossip. It's really fun stuff, actually.
Were there some, as you're going along, I'm sure had some preconceived notions about justices, jurisprudence, but now you're deep into it, you're in the weeds. Were there any surprises?
Yes. One of the biggest surprises is Brandeis. Mm-hmm. You know, Brandeis, Holmes says you should defer to legislation because legislation is the avenue by which the dominant opinion in society expresses itself. And so what we want is for society to adjust itself in an evolutionary sense to developments, to changes, to everything else. And so he develops what we now call positivism, which says that the law is what the legislation says it is. The Constitution is what its text is, and only what its text is. Don't give me any of this capacious interpretation. If the text kills it, then you kill it. Otherwise, you let it go, because we need to have the law adjusting to society's evolutionary changes. That's why Holmes defers to legislation. Brandeis defers to legislation because it's the process of democratic self-governance. I do a lot of writing in the First Amendment area, and I theorize the First Amendment and its relationship to democratic self-governance. I had always thought that those people who wanted to defer to legislation had a similar theory of democratic self-governance. Of course, in the United States, this theory of deference begins with someone named James Bradley Thayer, who writes a very famous article in the late 1890s in the Harvard Law Review saying courts should not second-guess legislatures because it's their constitutional right to pass the legislation. I went back and looked. He had no theory of democratic self-governance. In fact, no one has a theory of democratic self-governance before Brandeis puts this on the table and begins to develop a theory of democratic self-governance and also the rights necessary for democratic self-governance, which is why he develops the rationale for what becomes the modern First Amendment. He supports the court in Meyer versus Nebraska, which strikes down a law forbidding the teaching of German, whereas Holmes dissents. Holmes defers. Brandeis says this right of education is necessary for democracy, hence we should strike it down. It's Brandeis to whom we owe the modern theory of judicial deference in light of the values of democratic self-governance. I never knew that. And no one is joining him in the 1920s. It doesn't exist until the 1930s. And it comes right out of Brandeis, not out of Holmes, not out of Thayer. This was a huge surprise to me. And it was actually, they thought he was crazy writing these opinions. They wouldn't join him, they wouldn't, go along with him because no one thought about democratic self-governance that way. And that goes along with another fact which I had written about but never understood the deep implications of. We talk about First Amendment rights. You may know there's no First Amendment decision protecting First Amendment rights until the 1930s. In fact, the First Amendment was believed to only prohibit prior restraints until 1930s. And there's some hints to the opposite in the 1920s. Holmes begins to develop a theory of First Amendment as we would now know the First Amendment in November of 1919 in his dissent in Abrams, but it's Brandeis who carries it forward as a democratic right, as a right of self-governance. And I always wondered, why is it that First Amendment rights start to exist in the 1930s and 1919, whereas before they never existed? You know, we speak of ourselves as freedom of speech, but you could be put into jail for criminal libel, for blasphemy, for all sorts of things. And it was, Holmes writes an opinion, 1907, Patterson versus Colorado. He says, the First Amendment only prohibits prior restraints, and you cannot be put into you cannot be put into jail for a prior restraint, even if you're saying something false. But it says nothing, he says, about sanctions after the fact, and you can be put into jail for saying true things as well as false things. And this is 1907, Oliver Wendell Holmes, unanimous court. So why do we develop this judicially protected notion of the First Amendment right? And in my view, it's because, this is the theory I have anyway, the idea of self-governance in the US, like in Europe, even most European states at present, occurs through representation, not through democracy. It occurs through elections of your representative through political parties. And what happens in, you may know, in the progressive areas, political parties collapse in the United States. So you get, you get the initiative, you get recall, you get the direct election of senators, you get primary elections, direct primary elections, all taking it away from parties who are viewed as corrupt and self-serving. So if you cannot have representation through parties are not making the connection between voters and the elected, who is and how is that happening? And that is when we begin to reformulate ourselves as a democracy in which elected officials are accountable not to their party, but to the people themselves. And that requires, how do the people connect? And they connect through their speech. And you can see this developing, this new theory of speech. There's origins of it. Bryce talks about us as government by public opinion in the 1880s, but the institutional arrangements and the spread of that happens in the progressive era. When John Dewey writes with Tufts his book on ethics in the teens, he doesn't mention freedom of speech even as a right, not to the second edition in the 1930s.
Really?
Yeah. I mean, it's just not viewed as. Harlan Stone writes his one and only book, 1915, and he says, what are the great rights? He does not mention freedom of speech. Harlan Stone, the Caroline Product song. He doesn't begin to see this until the 30s. And and I think it has to do with the collapse of political parties. And if that's the case, it's Brandeis who's the theorist of that. He doesn't like political parties, he doesn't join political parties, he's a mugwump, and he's theorizing direct democracy, and that's why he's viewed as crazy in the context of constitutional interpretation and theory, and the First Amendment is good evidence of why.
So you got the Taft court. How many justices would you be looking at? Obviously, there was a
13.
13. That's the sum total of that aspect of it. What would be the one we would not even recognize? Was there a
Joseph McKenna? Do you know Joseph McKenna?
Other than I have an autograph of him, that's it.
No, and Edward Stanford. You probably don't know. No, there's a number of ones who are John Clark. Probably don't know.
Not at all.
Malone Pitney, you probably don't know.
Yeah.
William Day, you might know.
Yeah.
So there are a number of basically bad justices, non-entity justices, and then there's a whole set of very significant justices.
For among the justices, anti-Semitism, Brandeis obviously being Jewish, the only Jew at the time on the court.
First Jew.
And first Jew, excuse me. And did he write about that? Did he internalize at all about that? Whether there was any?
Well, he talks a lot about it in his letters. I mean, he talks about it too. He talks about McReynolds a lot about this. Holmes talks about that, and you look at some of McReynolds' circulation. So McReynolds circulates in the Supreme Court, they have a draft opinion and it circulates. They're called returns. So he has a return to a draft dissent by Holmes on whether an income tax can be applied to justices or whether that's a reduction of their salary. Holmes says, yeah, they can apply it, but the court rules no. You can't apply it, it's unconstitutional. And McReynolds says, I'm so sorry, he says, to you, underline, go wrong on this. He said, and it's a Brandeis dissent, he says, have you ever thought that God tried for 3,000 years to make sense of the Hebrews and couldn't do it and turned them out like fleas to prey on the rest of mankind. That's a return on an opinion to Holmes. I mean, so there's a lot of that going on with McReynolds.
How did Brandeis react to it? Did he just fluff it off, or was it a sense?
He fluffed it off. Cardozo could not. Cardozo was very sensitive. He was in a state of shock when he had to encounter McReynolds. And Brandeis talks a lot with Frankfurter, who's also Jewish, about how to prepare Cardozo for what he's about to experience. Brandeis has the most amazing passages about McReynolds. He's a Naturmensch. He spoke a lot in German, which means a natural man, like a beast, like Pharaoh, like a savage. Holmes tended to consider him like a Southerner. He said, like all Southerners, when things touched him, all he had in mind was himself. He just couldn't imagine anybody else in the room. He was a complete he didn't use the word narcissist, but that's what he meant.
Did you find that biographical study? I find it fascinating.
Totally fascinating. I love gossip, so it was a lot of it. It was really fun.
So McReynolds, he was really the outlier in the sense that he wasn't part of a team.
Everybody hated McReynolds. When McReynolds died, nobody went to his funeral. You can imagine what that means. But he returned the favor. When Brandeis retired, he refused to sign the letter of acknowledgement from the court.
Oh, you're kidding.
No. I mean, just to give you a sense of McReynolds.
Okay. So is there a point in putting together, it's 1988, you're kind of working on this book that's all-encompassing, it is heavy on your shoulders, I'm
Yes.
sure. Like, I don't want to be like the other two. Where you just simply say, enough. Aha, I've reached it, the box is full, I can't research anymore.
Well, as I said, Trump gave me the theme. How do you make law in a society that's so divided it can't even reapportion the Congress? Which is very similar to how do you make law in a society like ours that is so polarized it can't decide the outcome of an election. How do you, and this is a big issue for the court, and to watch them struggle with this question tells us something about how we make law or can make law now. The question of, it was a conservative triumph. I mean, he basically, what we say now, Harding packed the court. He didn't pack it the way Trump did by disturbing the rules, but he appointed any number of justices, and he got the court he wanted. It was a conservative court, much more than it had been before. Everyone understood there was a big change. The case that marked that change was a case called Atkins, where they strike down the minimum wage statute for women and for minors in the District of Columbia. Before that, there had been 5 votes on the Supreme Court to sustain minimum wage legislation, and so it came as a shock. And everyone understood we're not in Kansas anymore with this court. And then the conservative majority starts to overreach. They're checked in 1924. You may know that Robert La Follette runs for president, third party, 1924.
Wisconsin, by the way.
Wisconsin, very radically left state in the 1920s. And he runs on the platform that there should be no judicial review, that Congress should be able to override any decision by the court that finds the statute of Congress unconstitutional. Sound familiar? So he runs on that platform in 1924. Coolidge, cleans the slate. The other candidate is John W. Davis, who you might know. He was later Solicitor General. He was
Brown versus Board of Education.
Yes, Brown. He argued Brown versus Board. He's one of the great, but he was a terrible presidential candidate. The most boring speeches I ever read. And so after that, the court got cocky, and the conservative became more and more aggressive, and they set up the conflicts which would become very volatile during the New Deal. So it's a story about what happens when you have a conservative court that overreaches, and how it overreaches, and why, which is a little bit about what you'll hear from Professor Siegel.
He has an insight. He has insight of what we're going to be hearing here at 3:30.
It's a prediction.
Did she try it on you? Okay. As your appointment, the appointment process, it's easier to say Harding appointed conservative justices are ideologically appropriate for his mindset. But is there a group, is there a John Birch Society? Is there a group of advisors who are grabbing these candidates?
This is very unusual. This begins with Reagan. That there would be an outside group that would be the closest, and it was a considerable pressure group. When I said the Anti-Saloon League, we don't even remember the Anti-Saloon League, but the Anti-Saloon League is so powerful, it gets the 18th Amendment passed quicker than any amendment in the history of the country, quicker than the Bill of Rights is ratified, when they had only X number of states. It controls the Congress. It controls patronage throughout the country. And it doesn't care whether you're Republican or Democrat, they only care whether you're wet or dry. And to try to get a wet judge through, you would have a great deal of difficulty because of the control, but it's not like he brought them in-house. Harding didn't do that. In fact, I have intimate knowledge of the nomination processes, and mostly after Taft, there are 3 people who are nominated. One was George Sullivan. George Sullivan was the Colonel House of the Harding campaign. He was Harding's closest advisor. So he was going to appoint Sullivan no matter what. And in point of fact, John Clark resigns, and with 15 minutes, he sends in Sutherland's name. So no one was affecting that. The second one was a guy named Pierce Butler, very conservative, extremely aggressive conservative justice, and that was Taft. Taft and Vandervanner got that nomination through. I mean, Harding was dependent on his Attorney General, Harry Dougherty, who was extremely close to Taft. Remember, Taft was president, and Dougherty ran his campaigns in Ohio, helped to run his nomination. Harding nominated Taft at the 1912 Republican government. No, so Taft is extremely plugged in. And he's the kind of Chief Justice who's visiting with the president once, twice a week to talk politics and to talk everything. So he got his guy. And the third guy is Harry Stanford is Dougherty's guy, who he got through his assistant attorney general, who was from Tennessee, and who convinced Taft. If Taft hadn't agreed, he wouldn't have been in. But Taft was the veto gate. Taft controlled nominations to the court. He controlled nominations to the lower judiciary, etc. during Harding's regime. Coolidge, at the outset of Coolidge, and then Coolidge began to pull away. He began to give it back to senators because he needed their votes in the Senate, which was evenly divided. Remember his nomination of Warren for Attorney General after Harlan Stone gets defeated by 1 vote when his Vice President Dawes forgets to show up at a tie vote in the Senate. Yes, very famous. Dawes sleeps through it. So he needed the Senate votes, and Taft began to lose a lot of influence, but he was an extremely powerful man in this regard in Washington.
And this time frame, it ends in 1930, isn't that when President Taft passes?
He resigns, in early February, right?
Well, was there a reason for the resignation?
Yeah, he had strokes. Okay. January 7th, he returns from Cincinnati from the funeral of his brother, and he begins to suffer arterial sclerosis and strokes, and he begins to wander his mind. He goes to Asheville, North Carolina, and as Charles Evans Hughes says, he was afraid he would deteriorate so fast that he couldn't consent. He couldn't turn in his resignation, and he wouldn't be able to do it anymore, so they had to get him to resign. But he would only resign if Charles Evans Hughes would replace him and not Harlan Stone. He didn't want Harlan Stone replacing him. He was too progressive. And so, Taft once again, Taft appointed, I think, 6 justices when he was president. And then he determines who Harding is appointing, and then he dies, and from almost from beyond the grave, he gets Charles Evans Hughes appointed as his successor. Amazing influence on the court.
That's a piece of the history I had no knowledge of, to the extent. Wow, I bet there's probably nobody quite like that as far as just certainly quantity of justices being.
Oh, no one has actually. He did. Just to pick 3 achievements of his. He gets appointed Chief Justice, and he passes the Judicial Conference Act, the Judicial Act of 1922. This creates the Judicial Conference, and for the first time ever, it means that district courts are responsible for keeping their dockets up. And it turns out this act allows the Chief Justice to transfer judges to places which are in arrears. So it conceptualizes the judicial branch as a branch that has a function to perform. Remember, this is prohibition, and they have all these cases. Right. And so they're being flooded in certain places and dry in other places. And so he wants to transfer judges to where they're needed. No one had ever conceived the federal judiciary. It was always like you're a judge and you run your own courtroom and that's it. So localism and independence. Taft reconceives this as a branch that serves the function of deciding cases. And that means he reconceives the Chief Justice as the supervisor of the judicial branch. So today, when the Chief Justice gives the state of the judiciary, like a president, that's from Taft, who was the president and reconceived Article 3 branch. That's the first thing. Second thing, he passes the Judiciary Act of 1925. So before that, the Supreme Court was a final appellate tribunal. It had some discretionary jurisdiction, excuse me, but mostly it had to hear cases from mandatory jurisdiction, appeals, writs of error, etc. And that means that has profound implications for the sources of legitimacy, which are too complicated to go into unless you want them. But what happens is Taft gets through the revisions, which makes the court what it is now, a court that can pick its own docket. This changes the nature of the Supreme Court immensely. It means that the court has to justify itself in terms of its future-oriented shaping of federal law. Whereas in the past, the court was just like the Ninth Circuit. It justifies itself by how well it decided cases. And that puts pressure on the notion of what the legitimation function of the court is. That's very deep. And in point of fact, it's Jackson who theorizes that when he says we're not infallible because we're not final because we're infallible. We're infallible because we're final. That's the idea of an appellate tribunal. That it has the idea of being infallible but once you see that you're picking your own docket, you don't get to be like an ordinary final appellate tribunal because you're using it to shape the law. And the rest of us can say, well, you're really not final. I can, fight back, which is what conservatives did after Roe and what I expect liberals will do after Dobbs. Yeah. And so it changes the relationship of the court's legitimation to the public in profound ways. That's his second achievement. His third achievement, the Supreme Court, when Taft was Chief Justice, met in the basement of the Capitol, met in the old Senate building. It was Taft who lobbied and got through and designed our present Supreme Court building. Immense achievement. $10 million building.
The great pictures of that when you go to the Supreme Court, you'll see that.
But that's all Taft.
Yeah.
I mean, he lobbied it, he tried to get, I'm blocking on his name, the senator from Utah had a bill for, he had a $50 million government building bill on the floor of the Senate, and 1925, and Taft says, can you put in an authorization for a Supreme Court? But he said, no, I just want 50 million, I don't want to say what it's for. And Taft says, screw you. And he goes to the conference committee, and he works through his, he has so many contacts everywhere in the government. He works through his contacts in the House, the chair of the Buildings and Grounds of the House, and through other senators, and out of the Senate Conference Committee comes an authorization for the Supreme Court. And that's 100% Taft, working off the record, behind the scenes, Chief Justice lobbying.
Sounds like you have a profound appreciation for Chief Justice Howard Taft.
I have a deep appreciation for everything he's accomplished and a great understanding of both his strengths and his weaknesses.
Do you guys have any questions? We're really working him. He just finished his dessert, and the next thing you know. Is there a question in a normal, when this kind of conversation occurs, that people ask you that I should be asking?
Well, what is this for? I mean,
for the Jackson Archives. You're a guy of celebrity status like you. To have you here is fabulous. And we have had people, like Reba and others, and we try to sit down and just chat about the law. And we have thousands of interviews, and I love it. And so it's archived. It's archived opportunity, and
that's
to have
fabulous.
Somebody here with the Holmes Devise. I've only done, like I say, William Whitesick before. is a thrill for me, and I hadn't planned on this. So this is free flow. Complete free flow conversation.
Well, I'll tell you a discovery I had in that book,
yeah.
which was really innovative in history. So I'm mucking around I'm at the Supreme Court, and I'm mucking around in their attic just to see what I can find, because and we find a locked chest, but no one had the key. So we call a locksmith, and you have to come in, open the chest. There were, a lot of really amazing stuff there, some of it from my 20s, from my period. And then we had something like 10 locked books, leather-bound books. Again, we didn't have the key, so we had to call a locksmith, open them up. They are Butler's docket books for the 1922, 23, 24 terms, and Stone's docket books for 25, 26, 27, 28, 29 terms. No one had ever seen this before. I was able for the first time to do a statistical analysis of the difference between the voting in conference and the published voting, which reveals amazing things about the way the court works. So if you look at the unanimity rate now, what do you think the unanimity rate is of the Supreme Court now? What percentage of cases you think are unanimous?
80%.
Unanimous?
Oh, unanimous?
Yeah.
60.
What do you think?
60.
60? Somewhere between 20 and 30, percent unanimous. Unanimity rates collapse starting 1937. In my period, 88, 89% of published cases are unanimous.
Wow.
So it's been a mystery for a long, long time what caused the collapse in unanimity rates, which happened during the Chief Justice of Harlan Stone. And I was able to show that if you look at the unanimity rate in the conference, it's actually quite low. And so people are changing their vote. They're going along with opinions they don't believe in. It's a norm, I call it, of acquiescence. So Brandeis will write Holmes a note saying, I think you're wrong, but I'll shut up. Or he'll say, I think this has just got the antitrust. He says it, I think, about the baseball case, although don't put me down for sure about that. But I think he says, I'll acquiesce. He'll say things like that. And so you begin to see that the present court, however they vote in conference, I'm guessing, I don't have those records, but I'm guessing it's pretty much how they vote when they publish, whereas that was not true during the Taft court period. It's not true until a decade after that. And so the question is why they feel this obligation to put a unanimous face to the public. Turns out a really interesting historical set of questions.
Is that the same set of questions you would have in really Brown versus Board? I mean, obviously that was unanimous.
Right, but at that point, unanimity meant something.
Yeah.
So when you're deciding a case like Brown and you say we really have to be unanimous, it's because unanimity means something extraordinary.
Exactly.
Taft really struggled to get unanimous cases, and it mattered that it was unanimous, but even one dissent was like unusual. 89% of the cases are unanimous. Yeah, I mean, it's just a different institution. It's not the same institution populated by different people.
Wow, this is great. So you guys have any questions? I mean, this is unbelievable.
I don't want to ignore all the legal stuff, but I'm curious, did you go to high school with Albert Brooks?
Yes, his real name, you know what his real name is?
Albert Einstein?
Yes,
Yeah.
that's his real name. And I'll tell you a story about that. I was once joyriding, the way you joyride in Beverly Hills, and it was Albert Einstein, Albert Brooks, and Richard Dreyfuss, Larry Bishop, who's Joey Bishop's son, and who else was in that? I don't remember, 2 or 3 other people like that. And the cop stops us, and cops in Beverly Hills, they're very kind. They know that, they're residents, they're not going to do anything. So they get out, and they're going to teach it, And when you're a comic like Albert was, Al, you never stop making bad jokes. I don't know whether you know a young comic, but young comics, it's like a tick. They can't stop making jokes, and they're always bad. It takes a while before they can actually become funny. And so he was just making just quips after quip with the cop and pissing the cop off. And he turns to me and says, one more quip out of you, and you're going to actually spend the night in jail, all of you. So he says, what's your name? Richard Dreyfuss. What's your name? Robert Post. What's your name? Albert Einstein. That's it! That's a true story.
They do.
My father started out in live TV. Then he went to shows that you might have seen. Peyton Place, Rawhide, Gunsmoke. He did all of those shows. And then he went to movies. He did Hang 'em High. He did Magnum Force. He did Beneath the Planet of the Apes. So he became a movie director. And my niece and nephew grew up in LA, and they are all in the movies now.
Yeah.
In fact, I'm going back to see my mother in 2 weeks, and she'll turn in 2 weeks 102.
God bless you. That's fantastic.
Yeah, it is. And my nephew has just done a movie. He got the funding. They're going to start doing film about my mother.
Good for him. Good for him. Even though you didn't have the talent, would that is something, if you had the talent, would that something you would pursue?
Oh, yeah. Well, if I had the talent, I'd be a novelist. That's what I would be.
Well, you've
not to
written
be.
Well, you've written something that for the art for the ages. I mean, once that's going to be an edition that your name at the right there.
That's right, and it's $650 a pop. It's going to stay for the ages.